Hello, and welcome to the Safer Places NB Lawyer Referral Program training. My name is Trisha Perry. I am a lawyer, mediator, and arbitrator in the province of New Brunswick. I have been practicing workplace law for the past 18 years, and I have been asked in partnership with the Public Legal Education and Information Service of New Brunswick to facilitate this training program to those lawyers who have agreed to participate in our referral program, and we thank you for that. Our learning outcomes for today's session is to help build your understanding of what workplace sexual harassment is and who tends to be the target, and to build your understanding of the legal options that are available to those clients that will see you through this program. So starting firstly with what is workplace sexual harassment. I don't think you will be surprised to know that the most common understanding of this kind of behavior is behavior that's motivated by sexual interest or desire. So that can include things like making passes, soliciting sexual favors, questions about sexual activity, sexual touching. And certainly we have seen historically this kind of behavior in workplaces for a very long time. And we've seen numerous examples of it in the news in recent years, arising from the Me Too movement and Time's Up movement. And so it has generated a large societal conversation about this kind of behavior in the workplace and what is tolerable and what is not. However, workplace sexual harassment is often not about sexual desire or interest at all. It's about power and control. So it often involves sexist attitudes, negative assumptions, hostility, rejection, bullying based on certain characteristics, including a person's sex, their gender expression, and sexual orientation. This chart is useful in describing these various forms of workplace sexual harassment. So on the far side, we have the commonly understood forms, as discussed earlier, including those behavior that is truly motivated by a sexual desire or interest in another person. Then we have a whole category of behavior that is called gender-based harassment. And that is conduct, comments, or gestures that is motivated by things like sexist attitudes, things like stereotyping of persons, stereotyping based on a person's sexual identity or their gender roles. And these components are important to understand as you give advice to your clients. So gender identity is inherent. It is a person's inherent sense of being a man or a woman or something in between or distinct of those characteristics. Gender expression is exactly that, how we express ourselves to the world. So how we express our gender characteristics that are inherent to us. Sexual orientation is, in essence, to who we are attracted to. So it's the gender or gendered attributes that attract us to another person. So this I find is a really helpful diagram. So it's to start a conversation. It's not meant to be used to define any particular person or group of people, but it is helpful to explain these different protected grounds. And on that point, each of these are protected grounds under human rights legislation. So gender is in this diagram shown to be in your brain, right? It is only you that can identify what your gender identity is. Your sexual orientation can be described as being your heart. As Emily Dickinson once said, the heart wants what it wants. Sex can be described by your sexual organs, your physical attributes, and gender expression is the exterior component of those things. So it's made up of how you present yourself to the world. In my experience as a lawyer, and particularly as an investigator, investigating these kinds of complaints, there is, unsurprisingly and sadly, still many instances of overt workplace sexual harassment that is either motivated by sexual desire or interest, or motivated by stereotypes and assumptions and sexist attitudes. That still exists. But in large part, I am finding that a lot of the behaviors are being either supplemented by or replaced by conduct that is called microaggressions. So microaggressions are the easiest way to remember it is sort of a death by a thousand cuts. So it's conduct, comments, or gestures that are not as blatant or obvious, but more subtle. And it's often experienced by vulnerable persons, and it has a cumulative effect on the person receiving them. And so it's, as I said, it's this sort of death by a thousand cuts, these small little slights, insults that cause incredibly cumulative damage on a person. Some examples of that might be stereotyping. So women belong in the kitchen, or that movie I watched last night that was so gay. It could be exclusively promoting heteronormative behaviors like he, she languages in your workplace policies. It can include ostracizing, ignoring, and excluding certain persons. Women, for example, members of the LGBTQ2S+ community, visible minorities, persons with disabilities. And it is very often characterized by stigmatizing insults. So the following slide just shows some depictions of how concrete examples of how this shows up in workplaces. And so lots of assumptions based on a person's sex, gender identity, gender expression. And so we're seeing a lot of this in the workplace, and as lawyers who will be consulting with persons who believe that they are the target of workplace sexual harassment, it's important to understand that while overt behaviors still happen, they are often either replaced by or supplemented with these forms of microaggressions, which are equally as damaging. You won't be surprised to know that the impact of workplace sexual harassment on employees is significant. It often, almost always, frankly, leads to decreased job satisfaction and an increased likelihood of leaving. Most people simply want the behavior to stop. Most people are also conflict adverse. And so a lot of individuals choose to leave their employment as opposed to trying to address the situation internally. Or if they've tried to address it and the remedy for that has been unsuccessful. The conduct, it always causes the target to feel considerable amounts of stress and poorly impacts mental health. On organizations, the impact is equally as damaging, from a larger perspective. So we have the research tells us that this kind of behavior in the workplace results in increased absenteeism and turnover, as we described, as it relates to the impact on employees, increased sick leave, decreased productivity, and legal proceedings. So I want to talk to you now a little bit about what the legal obligations are and what the legal test is for workplace sexual harassment. So starting first with legal obligations, the genesis of protections against workplace sexual harassment is numerous. So employers do have a very clear legal obligation to both prevent and address workplace harassment generally, sexual harassment included. That comes from a couple of different components of the law. The first is common law. And so in every employment contract, whether it is expressed or implied contract, there is an implied provision that employees are entitled to a safe and harassment-free work environment. Occupational health and safety legislation also solidifies this obligation. And so you will find that in our New Brunswick Health and Safety Act and also in the Canada Labor Code for those employers that are federally regulated. It is also grounded in human rights legislation. So both the Human Rights Act in New Brunswick and the Canadian Human Rights Act prohibits harassment and discrimination on the basis of sex, sexual orientation, gender identity, and gender expression. And so that is where the cornerstones of these legal protections come from. Now, if you take all of those different forms of legal protection and distill them to their basic nature, you can essentially come up with a three-part test to determine whether or not someone is the target of workplace sexual harassment. Before I get into the test, I do want to say that even if conduct that is being presented to you does not meet this legal test, it doesn't otherwise mean that the behavior is okay. As you might expect, the law requires a certain level of severity and repetition before it constitutes legal harassment. But again, even if it doesn't meet the standard of the legal test, it doesn't mean that it's okay. And what we also know is that this kind of behavior, whether it starts small or large, unchecked, tends to continue and grow over time. So turning back to the legal test, the first component is that there must be, for workplace sexual harassment, sexualized, or gender-based conduct, comments, or gestures in the workplace, made either on a one-time, if severe, and it has a significant and lasting impact, or repeated basis. So there's a lot to unpack there, and we will, but that is the first component. The second component of the test is that the behavior, the conduct, comments, or gestures must be known or reasonably ought to be known to be unwelcome. The reasonable person test. And finally, the conduct, comment, or behavior must cause harm, and whether that's actual harm or reasonably perceived harm. And that can be things that threaten the health and safety of the employee, that demeans or belittles or causes embarrassment, or humiliation, or it also can be harm that results in placing a condition of a sexual nature on employment, training, or promotion. So these are just some examples of this kind of conduct. If we go back up our ladder to the first component of the test, what is the sexualized, and or gender-based conduct or comments that we're looking for? And again, so we can think about this in terms of suggestive name calling, rude or offensive remarks, sexual advances, questions or queries about a person's sex life. It can be belittling or making fun of somebody because of their sex or sexuality. It can be things like in a workplace distributing sexual pictures or emails or text of a sexual nature. It can be inappropriate inquiries based on a person's physical anatomy, for example. So imagine an employee who is a trans person and is being asked about who they like to sleep with and what their anatomy might look like, for example. It can also include things like unwelcome social invitations with sexual overtones. So these are sometimes examples. There are, of course, many, many more. So this is the flavor of the behavior that you're looking for when clients come to you and you're attempting to determine whether or not they have been the target of workplace sexual harassment before you get to the options that might be available to them. The other component that you're going to look for is, did the behavior occur in the workplace? So what is the workplace? It's actually very expansive. So it's really any space or situation where business is carried out. So that can include the brick and mortar of the building, like the physical office or location. It can include online communications, email, business travel, conferences, plane rides, train rides, car rides, training sessions, and work-related social gatherings. So think Christmas parties, summer parties, the staff go off to the bar for a drink after work, for example. All of those can be forms of the workplace. The other piece that you're looking for is that the behavior is either a one-time basis if severe, or on a repeated basis. So normally more than one act is needed to constitute workplace sexual harassment, because it is often the repetition that generates the harm. And that said, a single incident can constitute harassment when it's demonstrated that that incident was severe, firstly, and secondly, has had a significant and lasting impact on the target. So most often you're looking for a pattern of behavior. That said, it can be a single instance, but it must be severe and have a significant impact. In the case of sexual harassment, a single incident it may be viewed more significant depending on the party's relationship. So, for example, if the perpetrator is in a position of power or influence over the target, and that could lead to adverse job-related consequences, then oftentimes that single incident is viewed as being more significant. So all of that to say the context matters and the circumstances matter when we're determining severity. And again, I want to reiterate, a one-time behavior that is not severe and does not have a significant impact on the target, even though it may not meet this legal test of workplace sexual harassment, still doesn't otherwise mean that it's okay. It just doesn't quite meet the standard. And as I said before, we also know that unchecked, this behavior tends to continue. So the other component is that, and we are at step 2 of the test, is that the behavior has to be unwelcome. How do we know something is unwelcome? Somebody tells you, right? I don't like that behavior. I didn't like that comment. Please stop. Some people feel empowered to do that in workplaces. Many do not. And so the law imports the reasonable person test, with which you will be familiar. So of course it is the theoretical person who shows average judgment, skill, or care in their conduct. And so it's a contextual analysis based on, what societal standards have said is okay. And so in that, a person is obligated to look at things like tone of delivery, verbal cues, etc. So would a reasonable person in all of the circumstances understood that conduct, comment, or gesture to have been unwelcome? It's important to point out here that motive is irrelevant when it comes to the legal test. In my experience, most people don't intend to cause harm. The harm is caused nevertheless, and the law evaluates the harm, not the intent or the motive. And so as you think about, running a factual analysis through this test, it's important that someone might not have meant to cause the harm that they did, but it is irrelevant. So who tends to be the targets of this kind of behavior in the workplace? Well, simply everyone. Research does tell us that women are the most likely targets. However, many other vulnerable employees also frequently become targets. So, for example, members of the LGBTQ2S+ community, visible minorities, persons with disability. So there certainly is a component of our workforce that is more vulnerable to this type of behavior. Harassment can occur between coworkers, between subordinates and supervisors, men harassing women, women harassing men, same-sex harassment, sexual orientation, and gender identity harassment, and quite often third-party harassment as well, such as customers, suppliers, and vendors, depending on the work environment of your particular client. So it certainly isn't always restricted to coworkers. There are other forms of workplace harassment that I'll quickly just introduce you to, but they are not the subject of this training. And so we'll introduce you to those concepts without getting into the details too awful much. But essentially, a poisonous work environment is where there is behavior that is occurring that's directed not particularly at one individual person. So it could, for example, be an environment where sexist jokes are frequently shared. It could be an environment where there is a supervisor that tends to rampage through the office and slam doors and use expletives, for example. And so the behavior is not necessarily targeted to me, Trisha, but generally is creating a poisonous environment for me to work in. Workplace violence is another form of harassment. Personal and psychological harassment, that can be on the basis of a protected ground under human rights legislation or not, but it's most often referred to as bullying. And abuse of authority is where somebody in a position of power uses that position without legitimate work purpose to negatively impact someone's employment or their employment prospects. So those are just other forms of harassment to be aware of. This program is, of course, restricted to sexual harassment. So notwithstanding the continued prevalence of this kind of behavior in the workplace, as recently demonstrated by the Me Too movement and the Time's Up movements, responses like this still exist. And I still hear these a lot in the training programs that I give. So gosh, the lines are so confusing. It's so gray. I don't know what to do. Can't you just compliment anyone anymore? People are just so sensitive. I hear that one frequently. I'm not meeting with a woman alone again. That was a huge response to globally to the Me Too movement. And this is the final one is very much a maritime response in my experience. Oh, that's just so-and-so. Look, they're a really good person. They have a family. They don't mean to cause any harm. Don't worry about it. So because of that, though, and because there's a lot of gray when it comes to delineating mild and serious forms of gender-based offenses, it creates this natural confusion. And then how do you eradicate that? So you might have questions yourself about, well, where is the line? What is mildly versus deeply offensive? At what point is intervention necessary or possible legally? So in response to questions and comments like that and the movements that I've referenced, Dr. Kathleen Kelly Reardon, a professor emerita, developed a spectrum to help differentiate among different types of gender-based harassment and offenses. So it's intended to be a bit of a blueprint for people and organizations in becoming familiar with levels of offense that can cause harm in work relationships and create or perpetuate hostile work environments. So the range starts from generally not offensive conduct and comments such as your hair looks nice today, or that's a pretty dress, for example, to egregious sexual misconduct such as sexual abuse or sexual assault. This is not a legal tool, but it is a helpful guide to help you understand the severity of behavior. So when clients come to see you, it helps you gauge the degree of severity that they have been subjected to in terms of offensive behavior. So just running through these quickly, starting at the top end of the spectrum, these are generally not offensive types of conduct or comments rather. As you know, the circumstances always matter, right? So we can't look at any of these examples in a vacuum. So the "you look nice today," on its face is not offensive. If somebody said that to you, though, with a leering tone, or they repeatedly said it to you every day and stared at you with love in their eyes, at some point that's going to become offensive behaviors. But putting context aside, which as lawyers we can never entirely do, but for the purposes of this training, we will. These are relatively non-offensive types of comments. Moving down the spectrum, we're talking about things that are comments that are awkward or mildly offensive. And so, we can't speak frankly around you women anymore, for example. That's mildly offensive. You would say that as a woman, or as a person who's gay, for example. We're getting to a level that is mildly offensive. And so as we move down the spectrum, we are moving into offensive behavior. So, and again, it's not necessarily intentional or overt, but things like unwanted hugs or uninvited hugs. Does that mean you can't hug anybody? No. Is it best practice to ask first? Yes. I'll give you an example using the reasonable person context. So if Joe has just lost his mom and he comes back to work and I give Joe a hug and say, gosh, I'm so sorry for your loss. And Joe freezes and doesn't hug me back and looks mortified by the fact that I have hugged him. Have I engaged in workplace sexual harassment? No. Am I now put on notice that hugs are uninvited by Joe? Yes. So if I continue to do that behavior, chances are that behavior is going to be considered with relative quickness to be offensive. Moving down the spectrum, we have seriously offensive behavior. So that is demeaning words or slurs that refer to someone's sex, gender identity, or orientation. It might be jokes about a person's limited intellect or skill due to their gender or sexual orientation. So think blonde jokes, for example, is an easy one. Demeaning comments about somebody's physical attributes. Evident sexual misconduct is exactly that. So that is examples include grabbing people, unwelcome holding, unwelcome kissing, pursuing a personal or intimate relationship with someone who has already expressed their disinterest in that, making demeaning comments about a person's sexuality. And at the end of the spectrum, we have egregious sexual misconduct. So that is, again, egregious. Exposing genitals, pressing up against someone suggestively, and of course, forcing or coercing someone to have sex. And so this spectrum can be a bit of a tool for you as you evaluate the factual circumstances that your clients present to you in determining what options are available to them. So turning to those options and consequences, there are several for employees who engage in this kind of behavior. Perpetrators of workplace sexual harassment by their employer can be disciplined up to and including termination. They can be held personally financially liable under different forms of legislation, including health and safety and human rights. There is the possibility of a criminal offense or charge under the Canada Labour Code. As we know as lawyers, ignorance of the law is not an excuse. So there are tangible consequences for employees who engage in this kind of behavior, and certainly tangible employer consequences. As I said earlier, employers are legally required by common law and statute to provide a safe and healthy work environment. And so failure to do so can result in significant financial liability. And so it's also important to understand that employers are responsible for the actions of their employees if they have not exercised due diligence, and that's called, as you know, vicarious liability. So a simple lack of awareness by management doesn't eliminate this liability, and it does apply to all workplaces. And so that is an important component to understand as well. So what are the options for your clients when they present to you with a claim of workplace sexual harassment? So the first option, and I will explain these in no particular order, but the first option is an internal workplace complaint. So in 2019 in New Brunswick, our Occupational Health and Safety Act was amended, and such that employers in this province who are provincially regulated are all, regardless of size, required to adopt and implement a policy with respect to workplace harassment. The policy, according to the regulations, has to include various things. So it has to include an investigation procedure. It has to include information about how the affected employees will be informed of the results of any investigation, a procedure to implement corrective measures if workplace harassment has been found to have occurred, follow-up measures to be used with the target employee, identification of training needs, a statement that every employee is entitled to work free of harassment. And it is to identify who employees report their grievances or their concerns to. So the law requires this in the province, that all employers have this, and there is a similar requirement under the Canada Labour Code for federally regulated employers. So a really critical piece of a workplace policy outlines informal and formal resolution processes for allegations of workplace harassment. Now, I should say this policy that is required to cover all forms of workplace sexual harassment, including sexual harassment. So talking just a little bit about what are the means of addressing complaints internally. So if a client has come to you and they have an internal workplace policy, or they don't, there are still options for them to talk to their employer about the behavior. So some informal types of resolutions include facilitated conversations, coaching, mediation, and group processes. The goal here is resolution, not punishment. So you typically would want to suggest informal resolutions within a workplace if the employer is willing to do that. And most often they are when faced with potential legal ramifications. The goal is, again, resolution. And so it's appropriate to use these types of resolutions when the behavior is less serious. So if we go back to the spectrum that we went through, you certainly would not want to use informal resolution processes for egregious sexual misconduct, for example. You would want to think about these when you're talking about less serious forms of workplace sexual harassment, less serious examples on that spectrum. So a facilitated conversation is if the two parties are uncomfortable meeting alone, so your client and the alleged harasser. So a neutral third party, normally a member of management, can meet with them to help facilitate a conversation. Coaching is another option. So often one or more parties need guidance and direction. So it's a one-on-one process where somebody within the organization would meet with a perpetrator to talk about encouraging self-awareness, recognizing the impact of their behavior and actions on others, to help them understand why the person that was the target of this behavior is offended. Mediation is often involves an impartial third party that hears both sides of the situation within the workplace, and again encourages discussion with the goal of resolving the conflict and figuring out a way to work together moving forward. And so those are the informal types of processes that you can be suggesting to your clients. And again, it does require buy-in by their employer, but is often very useful tools in trying to resolve a low-level misconduct. But as I said, every employer is required to have a policy, and all of those policies are required to have a formal investigation process. And so the goal of that process is fact-finding and to conclude whether or not workplace harassment took place. So that can be an option that you're suggesting to your clients. If their employer does not have a policy or does not have a reporting form, you can look to the Safer PLEIS-NB website for some resources. There are sample policies, and importantly, there is a sample template for employees to use to report to their employer, even if they don't already have a policy. This will trigger to the employer that something is happening within their workplace. And ideally, they see that they have a hot potato in their hand and must do something meaningful about it. So another option, again, in no particular order, is a grievance under an applicable collective agreement. So if working in a unionized environment, victims of workplace sexual harassment are entitled to file a grievance for the employer's failure to maintain or create a harassment-free workplace. And so the purpose of that process is to make the employee whole following wrongful conduct by another employee. So depending on the circumstances through that process, the griever, your client, could be entitled to several different remedies if successful during an arbitration hearing. So that could include things like being reimbursed for any sick leave taken, general damages, past loss of income, if any, future loss of income is also a possibility, and other damages like aggravated and punitive damages. Another option, which is not available to unionized employees, is a civil action. So targets of workplace sexual harassment can file a civil lawsuit on the grounds of battery or assault. But again, when we're talking about the employment relationship, the law imports into every employment contract, whether it is written or oral, an implied term that the employee is entitled to a safe and harassment-free workplace. So if that is not happening, the employee can sue for wrongful dismissal, which is essentially constructive dismissal, meaning by failing to provide a safe and harassment-free workplace, the employer has unilaterally changed a fundamental term and condition of the employment contract, and then that creates the ability to file civil suit based on wrongful dismissal. If successful, that process can involve things like an award of aggravated damages. So that's meant to, as you know, compensate for harm suffered beyond financial loss. Compensatory damages, so that is things for like lost wages or injury. Punitive damages to essentially punish the wrongdoer, which can include the perpetrating employee and or the employer. And nominal damages to recognize essentially that a wrong has been committed, but if it is not severe, then the damage level is not aggravated. So civil action is likely the most expensive option for your client to pursue, because as we know, legal representation is not required in our courts, but it's often advisable. And so that can be an expensive process. If we go back to the internal complaint under an organization's harassment policy, there really is no cost to that. And under the grievance process, your client will be represented by their union, and so there's no real cost to that. So this is one of the more costlier options in terms of filing a civil suit. Another option is a human rights complaint. As indicated previously, the New Brunswick and Canadian Human Rights Act protect against discrimination on the basis of sex, gender identity, gender expression, and sexual orientation. And so that is applicable to the employment relationship. This is a free process in the sense that the commission takes carriage of the complaint. The employee may nevertheless wish to retain a lawyer for their own purposes, but it's not necessary. In terms of process, some things to be mindful of is that a complaint has to be filed within 12 months of the alleged incident, or when we're talking about ongoing incidents, 12 months within the last incident. If just a tip, if the employee is unionized, the Human Rights Commission will often require that process to be followed through first before it will accept or investigate rather a human rights complaint. And the purpose of that, of course, is to avoid concurrent proceedings happening at the same time. So if your client is unionized, then their first real option is either the internal complaint and or filing a grievance. To file a complaint with a commission, complainants must fill out a complaint form, and this is all set out on the commission's website, quite easy to follow. In terms of process, if you're not familiar, what happens then is a human rights officer is assigned to the case and can dismiss the complaint or suggest a pre-complaint intervention like mediation or investigation. Complaints really under this process are not often dismissed. They will be if it is deemed to be on its face without merit, frivolous, vexatious, or made in bad faith, or if it falls beyond the commission's jurisdiction. So for example, if it is a complaint of bullying that is not based on a protected ground, the commission would not have jurisdiction to accept the complaint. And so those are the circumstances in which it would not be successfully at least investigated. The commission may also dismiss a complaint if the complainant has declined a fair and reasonable settlement offer, just so you're aware of that as well. Through the commission process, there is often mediation is offered, and again, that's a free process. And investigations, if early intervention is not successful in terms of conciliation or mediation by the commission, often an investigation will follow. If the complaint has been deemed, again, on its face, on a prima facie basis, to be with merit. An investigation will follow. That investigation on its conclusion can result in either the dismissal of a complaint, referral back to mediation, or hearing in front of the Labor and Employment Board, which is deemed under the Human Rights Act to be a board of inquiry. The board of inquiry has expansive powers, much like an arbitrator does under the collective agreement process. So an arbitrator, or the Labor and Employment Board could award things like reinstatement with back pay, general or special damages, etc. The difference between the arbitration and human rights processes as administrative tribunals and the courts is that the courts do not have the jurisdiction to reinstate an employee to their employment, whereas an arbitrator and the Board of Inquiry by the Labor and Employment Board do. So that is one of the fundamental differences between those options. And again, as I mentioned, if the employer is federally regulated, then it would be the Canadian Human Rights Act that would be applicable. The final option is a police complaint. And of course, this depends on the nature of the alleged conduct, but sexual and other forms of assault are considered very serious criminal offenses under the criminal code. So the police can be asked to lay charges. In these circumstances, the victim would report criminal harassment or sexual assault to the police, who then, of course, as you know, arrest the accused or charge the accused. If a charge is laid, the Crown Prosecutor will be responsible for overseeing that process. Victims do, as you know, lose a fair bit of control over this process, which can be very damaging and resulting in secondary trauma sometimes. But the Victims' Bill of Rights does still entitle them to information, participation, to seek restitution, protection, to make a complaint. And there are organizations in the province that work actively to support victims of a sexual assault and sexual violence. And so those resources are important as well. If your client is reporting serious conduct of this nature, sexual violence, NB is one such entity. So if the charges are not approved, victims targets still have some options in terms of requesting a peace bond, for example, or following one of the other legal avenues as applicable that we've already gone through. So as you navigate this journey and providing clients with legal advice around workplace sexual harassment, there are some other places that you can access for resources. So the Safer Places NB website is one. PLEIS-NB website has helpful material as well. The New Brunswick Human Rights Commission has lots of great information, as does WorkSafe New Brunswick, as it relates to the legal requirement for organizations to have a workplace policy against workplace sexual harassment. WorkSafe NB also provides guidance as to when a behavior might then trigger a workers' compensation claim. And the only time that happens in this context is if your client has been the victim of an acute reaction to a traumatic event. And so it's quite limited in the province in terms of what kind of behavior might result in a successful workers' compensation claim, but certainly those resources there for your perusal as well. So I want to thank you for taking the time to listen to this video this afternoon. As I said, I am a practitioner in the province. If you find yourself in a situation that you don't entirely understand or would like to chat through, I am happy to be accessible to all of you as you navigate your way through the program. And again, thank you very much for your attention and good luck.